Hello, I'm Jim Turk, and I'm the director of the Center for Free Expression at Toronto Metropolitan University. And I'd like to welcome you to today's first in a series of panels and discussions that the Center for Free Expression is having on the theme of threats to academic freedom. Today's is focused on the issue of collegial governance. It's when collegial governance fails. And it's an inside look at what happened in a very dramatic case at the University of Toronto's Faculty of Law. I want to begin, however, by acknowledging that the land on which I'm speaking to you today is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit and the Williams Treaties with multiple Mississauga and Chippewa bands. I also want, before we start, to thank the co-sponsor for today's discussion, and that is the Canadian Association of University Teachers. The university has a mission, a dual mission of educating students and advancing knowledge. And the foundation of the ability of the university to fulfill that mission properly and in the public interest rests on two pillars. One is collegial governance, and the second is academic freedom. Universities are unique, and the notion of collegial governance, collegial doesn't mean congeniality. Collegial refers to the university being a collegium, and that the members of that collegium should be responsible for the academic decision-making and academic affairs of the university. And that's a principle that's been embedded in university practice in Oxford and Cambridge for centuries, and exists in Canada as well, in which there are senior academic bodies called senates or general faculties councils in universities across the country that are responsible for the academic affairs of the university, and boards of governors that are responsible for the financial and administrative affairs. That principle of collegial governance of academic affairs ensures that academic decision-making is made on academic criteria and not the interests of donors or outsiders or others, that the integrity of the institution is protected. And it's further protected by academic freedom that ensures that the academic staff of the university have the academic freedom in their teaching, in their research, and in the internal affairs of the university to use their best professional judgment to speak their minds without sanction by the university. Those rights have historically been threatened from time to time by the intervention of donors, by outside political interests, and it's been viewed as the university in some ways can be under threat from outside. But it can also face challenges from inside, and where people inside the university pick up the interests of donors or of political groups or religious groups or whatever. So it's a complex mix that can lead to problems. We recently had a case at the University of Toronto and the Faculty of Law that's going to be the focus of today's panel. It resulted in the Canadian Association of University Teachers censuring the University of Toronto for its violation of academic freedom. This is an extraordinarily unusual action by the Canadian Association of University Teachers. In fact, it hasn't had to censure a major university in this country since 1979. So there's a period from 1979 to just the last year or two when there were no censures. But what happened at the University of Toronto raises such profound issues of academic freedom and of collegial governance that we have made it the focus of today's panel. And I'd like to introduce the two people who are going to be discussing it. They're two very senior members of the Faculty of Law at the University of Toronto who are going to look at the questions of how did this happen? What went on within the law school? What are the lessons to be learned for others, other universities and other faculties across the country from this instance? I'd like to introduce our two participants. First is Anver Emon. Anver is professor and Canada Research Chair in Religion, Pluralism, and the Rule of Law. He's a leading scholar of Islamic law. His research focuses on pre-modern and modern Islamic legal history and theory, pre-modern modes of governance and adjudication, and the role of Sharia both inside and outside the Muslim world. He was named in 2014 as a Guggenheim Fellow in the field of law, and in 2017 was awarded the Kitty Newman Memorial Award in philosophy from the Royal Society of Canada. He is the author of several books, including Islamic Natural Law Theories, and co-editor of Islamic Law and International Human Rights Law, Searching for Common Ground. He is the founding editor of the Middle East Law and Governance Journal and a series editor of the Oxford Islamic Legal Studies series. Welcome, Anver.
Thank you very much for having me.
Our pleasure. Our second participant is David Schneiderman. David is professor of law and political science at the University of Toronto. He teaches courses in Canadian and US constitutional law and on international investment law. He's the author of more than 80 articles and book chapters, and the author or editor of 12 books. The two most recent are Red, White, and Kind of Blue, The Conservatives and the Americanization of the Canadian Constitutional Culture, and secondly, Investment Laws Alibis, Colonialism, Imperialism, Debt, and Development. Previously, he has served as the research director of the Canadian Civil Liberties Association and is the executive director of the Center for Constitutional Studies. Welcome, David.
Thank you, Jim.
It's a pleasure to have both of you here. I'd like to just briefly share with the audience the format that we're going to follow. David and Anver are going to be in a conversation about these issues for about 45 minutes to an hour, and at which point they're going to bring you, the audience, into the conversation. If you notice, we're using a version of Zoom that has a question and answer option. So if you look down at the bottom of your screen, you'll see a Q&A button. If, as you're listening to them, a question comes to mind that you'd like to ask them when we turn to the audience part of the discussion, just click on the Q&A button and write down your question. When we turn to the audience, and Anver will ask Ange Holmes, the coordinator of the Center for Free Expression, for the first question, and then each subsequent question. So she'll read out the question, then Anver and David will have a chance to respond, and then they'll go to the next question. So please feel free. We'd encourage you to ask questions, whatever you'd like that comes to mind as you're listening to them. Other than that, the floor is yours.
Thank you. Well, I'd like to open the conversation we want to have with all of you today, just by giving you just a few minutes of backdrop to what David and I have written and why. And so, as Jim mentioned, the two of us are members of the Faculty of Law at the University of Toronto, and we were present during the events that have been variously called the IHRP scandal, the IHRP standing for the International Human Rights Program, and there was a hiring problem that we confronted there. We'll talk a little bit about what we encountered. Many of you will already know it. What we did, though, over the last year was we, at the invitation of colleagues, is author an article together around what that scandal was like, what happened, and we did our own analysis, looking at a variety of archives. You know, CAUT had its own collection of materials that it put together in anticipation of its censure vote in April of 2021. There was the Cromwell report itself that was a source of considerable information. And a year after all these events occurred, also the Canadian Judicial Council was taken up on judicial review for its decision on its hearing regarding Judge David Spiro and his conduct in these particular affairs at the University of Toronto. And in the process of that judicial review, the CJC had to make a variety of disclosures, which we then had review of and looked at closely. And so, putting together all those different collections and those sources, we began to try to craft a narrative around what happened. Why did it happen? What were the arguments that were used? And what were the different elements at play, whether it was an internal actors across the university or external actors, and so on. So that's that's what brings us both of us here to this event in terms of our academic work. But a larger question that I think structures the paper is, why even write about it? And part of what's concerned myself, and I think I can also speak on behalf of David on this, is that for both of us, we couldn't help but notice that academic freedom is like democracy. Both our ideas, both our principles, both our commitments that we make, they don't always have rules and regulations on how to enforce them and how to make them valid, how to execute them. There's oftentimes unstated practices, unstated principles, which we oftentimes noticed when they're noticed most in the breach. And so what we appreciated was, being in a culture where we are watching democratic, bastions of democracies turn away from some of those more representative principles and those more accountability principles, do we nonetheless see analogs in the context of how universities are governed? And that got us to the point of thinking about academic freedom not as a standalone idea around what intellectuals do once they're tenured, but rather academic freedom as the result of collegial governance, and that collegial governance as operationalized is a sine qua non of academic freedom. And so we want to think together with you in the audience, and obviously it was something we put our heads together to think through as we wrote the article, is how do we capture this issue of collegial governance and its breakdown, and then related directly to academic freedom and its demise. So that really sets the backdrop for that. And so that's what I want to sort of begin this conversation with. But I know David has a couple questions he might want to start us off with.
Yes. So just so the audience understands what's going on here, we've co-authored a paper, but we're each going to take turns posing questions and answering them. And so we've each taken responsibility for different parts of our work. And so I'll begin by asking Anver a few things about academic freedom. And firstly, why should we really care about academic freedom? Why should audience members be concerned that there's a threat to academic freedom, both in the past and in present day?
At least for me, academic freedom is something that, well, let me put it this way. I take comfort in the University of Toronto's statement of mission and purpose. And that statement of mission and purpose says robustly, in a way that I haven't seen expressed anywhere else, that universities are the ultimate institution responsible in a democratic society for cultivating a space where we can ask difficult questions, uncomfortable questions, questions that we may not want to address out anywhere else, but nonetheless can be asked and answered and debated in a university setting. And that ultimately promotes a more healthy, robust, and inclusive democracy. And so as academic freedom goes by the wayside, we run the risk of fundamentally undermining health and robustness of our democratic culture and the potential inclusiveness they can have therein.
So is academic freedom under threat because of the rise of illiberal democracy, voter apathy? I think the turnout yesterday in the American election was below 50%.
Yeah.
So is this just part of a larger cultural malaise?
I do worry there is a cultural malaise that makes us less motivated to protect it. And you can certainly see it in our context at the law school around the level of silence that we heard in the context of this scandal. But I don't think it's just, voter or academic malaise. I also think it's institutional buildup and design and structure. If we think about universities are complex institutions, they're no longer just islands where intellectuals gather and think big thoughts. They're engaging in the marketplace. They're participating in the economy. The University of Toronto is one of the largest employers in all of Ontario. And as a result, universities then have to deal with labor relations. They deal with patent law. They deal with industry. They deal with a number of things, which we like to think is a good that they bring to our larger society. But it also means that you have to build up universities with a large complement of staff who aren't necessarily doing the research, the teaching, or the writing, but are doing all the work that makes that writing and research have an effect in the larger world. The problem, though, is as you build out what we call sort of a university bureaucratic staffing complement, that bureaucratic staffing complement acts as a bulwark between effective collegial governance and academic freedom. Staff don't enjoy academic freedom, certainly not at the University of Toronto. And that became an issue in our case as well with the director of the Human Rights Program. So staff members are keenly engaged in the governance of the university, but don't enjoy academic freedom, or at least whistleblower status in protecting academic freedom. Then we're left with a return to Weber, whose own work, as you know, David, raised questions around whether or not bureaucratic cultures actually impede democratic accountability. And that's where my concern is also just in the institutional design, governance, and effective collegial interaction on these matters.
So how does the Palestine exception fit into this? And we're going to talk a bit about it as we dig deep into the IHRP scandal. But it plays a role in this controversy that we experienced here. And so how does it fit in the rise of the bureaucratic administration of the university and I think democratic decline that we witness all over the place?
Well, so in this particular case, it came about because the particular candidate who had the consensus among the hiring committee to be hired as the director of the International Human Rights Program was also a scholar on international human rights law related to Israel and Palestine. She wrote a lot in that field, nothing particularly out of the ordinary. And as experts in the field have noted, her writings fell well within the realm of what one would expect in that field. And in fact, had successfully gone through peer review on a number of her publications. What was alarming in this case, and where the Palestine exception comes into play, is that it was precisely that writing that she did that was critical of Israel that became the reason why external parties got involved, the reason why Gerald Steinberg of NGO Monitor sends a memo to the Council on Israel-Jewish Affairs, who then contacts a former board member, then Justice David Sparrow of the tax court, who was also an alum of the law school and a donor to the law school, who then had a conversation with a university advancement officer. The university advancement officer then had a conversation with people at the Faculty of Law about an appointment that should have been confidential from the very get-go. And we still don't know, despite the entirety of all the different investigations that have occurred, how it is Gerald Steinberg of NGO Monitor got the name, got the leak. We don't know how that happened.
Yeah, we did learn from the Canadian Judicial Council disclosures of the Spiro hearing that Steinberg was advised about the appointment from a faculty member here at the law school.
Well, I understood it as a faculty, so I don't know what that meant. Is it a faculty member somewhere in the universe? Was it a faculty member at U of T or a faculty member at the law school? We simply don't know the full details of what that is and how that occurred. But no, you're absolutely right. There was some indication that the leak was from a faculty member.
So, the Palestine exception, just as a general phenomenon, as it's come to be called, is looming over all of these events.
That's right.
And I wonder if the fact that it engaged Israel-Palestine made it very difficult for our colleagues to think about taking a position or a stand, given the the seeming awkwardness of weighing in on this event, even though the Dean of Law appeared not fearful about weighing in on the debate.
No, I think that it couldn't not have. I mean, we live in a political culture where this is one of those hard conversations that people really struggle with. And it's couched in a larger conversation we're having across academic sectors around the definition of anti-Semitism and the IRA definition, which the CAUT, for instance, has raised questions about, which the University of Toronto has refused to endorse, but which the federal government uses as its definition of anti-Semitism, which the Ontario government uses as its definition of anti-Semitism. And of course, the problem with that definition is that the examples provided by the association around what could be included within that, which of course includes critique of Israel, which has been the longstanding critique of that definition. So if critique of Israel is tantamount to anti-Semitism, then one of the concerns that we've had at the law school was one thing that might explain the general silence over the scandal has been, does concern about failures in collegial governance render someone subject to accusations of anti-Semitism? And that became, I think, that was something that we don't know as a group of dissenters there was a few of us that dissented. We don't know as a group as to whether that was the case, but it's certainly something that remains an ongoing question for us in terms of how well can we engage even our own collegial governance practices, despite the broader context of a hot and controversial topic.
Okay, well, thank you.
No, thank you. But I think, David, what I want to do is I want us to, obviously the audience here might not remember all these things that happened, but also what the law school is like. I mean, there is a larger history to the Faculty of Law at the University of Toronto, a history that we've talked about. But I was wondering, these crises and these scandals don't just come out of nowhere. They're not just created in a vacuum. There is a larger context in which governance problems occur. And so I'm wondering if you can provide some backdrop to how governance at the law school has operated since you've been there, and in light of some of the things that you found and learned along the way in the research.
Sure. So governance at the Faculty of Law at the University of Toronto is decidedly uncollegial. Now, I won't be speaking to the history of governance at the law school or at the university. There are numerous episodes that have been documented in other venues, but just the experience of being a faculty member here at the law school has taught me that intervening in internal affairs at the law school, opposing decisions made by the law school administration are not welcome. The dean's office has almost entire control over internal affairs at the law school. Most every decision will be run through the dean's office, and more often than not is under the sole purview of the dean. There are, to be sure, committees established that are meant to be consultative mechanisms. Often, in my experience, these haven't been used effectively or at all. And certainly the IHRP fiasco is a good example of that, because the recommendation to appoint Valentina Azarova was made by a committee established under the auspices of the IHRP and chaired by one of our colleagues, Audrey Macklin, who's had a longstanding relationship with the IHRP. And that committee, three-person committee, chaired by Macklin, but composed of one employee, Vincent Wong, at the IHRP, and also the assistant dean, Alexis Archbold, were the three who recommended that Valentina Azarova get the appointment. And it was a pretty easy decision for them, given her qualifications and academic record. And then the decision made by the dean to reverse, ignore, put a halt actually to the appointment process was entirely made by the dean unilaterally. So just to return to the culture of governance, The dean controls most matters. Faculty council is a place where self-government at this small unit is expected to take place. And it's largely a reporting mechanism. The dean awkwardly chairs faculty council, sets the agenda, and so controls proceedings. And this became very clear again during the course of events in the fall of 2020, when we tried to raise concerns about the future of the IHRP.
Well, I want to maybe go back and just get a little bit of the back and forth attempts to create a collegial opportunity here, because, you know, you and I, well, can you talk a little bit about how it is you came to know about the problem, and what were the efforts that you made internally to address it, and how were those received, number one, and number two, what were the options thereafter in terms of engaging on this issue and addressing concerns about accountability, transparency, and collegiality?
Sure. So I came to learn about the dean putting a halt to the appointment process through a couple of emails I received from colleagues in Israel teaching at law schools there, wondering if it could be true that the dean would intervene because of Valentina Azarova's work on the international law of occupation, of which Israel and Palestine are, of course, perfect case study. And I didn't know anything about it. And so sort of put out some inquiries, in particular to Professor Macklin, trying to find out more about what was going on. I then subsequently wrote to the Dean Yakibuchi, before this matter became public and before he announced publicly his decision to halt the appointment process. I also wrote to, via email, this was, of course, in the midst of the COVID pandemic, wrote to several colleagues, 4, if I recall correctly, who I thought would be able to influence the dean's decision-making. And for some of these colleagues, I was not particularly close to them, but was worried about the reputational harm that would ensue to the faculty of law if this became public. And so asking that they inquire with the dean about whether this is a wise course of action and whether he might reconsider and whether we might actually bang heads together to try and resolve this problem. I never heard anything back from the dean. I don't know if any of those colleagues that I asked to write heard back. I know that some of them did write to Dean Yakibuchi. So as far as I know, these pleas were met with silence. At that stage, there's no venue with which we can communicate with each other collectively. There's no listserv that faculty members have access to communicate with each other about matters that are important or even matters that aren't important, right? Practical information, or I have a dining table set to give away. Does anybody need it? We have no means actually of communicating with each other other than through, again, the dean's office. The dean's office has control over that listserv. And so if we want to send a message to colleagues collectively, we must make a request through the dean's office. And the dean then gets to filter those messages that go out to colleagues. It reminds us of something that we learned about, Anver, you and I learned about, in Bill Graham's autobiography, where he reports that when he was a student at the law school at the University of Toronto, Dean Wright insisted that faculty members not have telephones in their offices. Graham explains in his autobiography that this was because the dean wanted all telephone communications to go through his secretary, and that way could control who was speaking to whom and could have his finger on the pulse of what his faculty were doing externally, never mind internally. It was a smaller place then and presumably easier to communicate with each other. Here we have a faculty anywhere from 50 to 60 at any one time. And it's very difficult actually to communicate with people, particularly in the midst of the COVID pandemic. So this is a real problem at an relatively small institution such as ours. And we attempted, as I think I'm going to ask you about, we attempted to try and resolve this problem by creating our own listserv in the midst of this controversy.
Well, before we get to your questions, one of the things that I think the audience might benefit from is obviously in the context of the reaction of the dean's, in reaction to the dean's decision, the dean didn't simply decide and give no reasons. He did give reasons for not hiring Azarova, for scuttling the hire. Can you just summarize what those reasons were, both at the time and we can discuss about how they also evolved over time, but I'll leave it to you to decide what part of those questions you want to address now.
Sure, I'll just maybe survey quickly some of the reasons, but they were shifting. So the reasons that were communicated to Professor Macklin over Labor Day weekend, and it's important that our audience knows that all of the decisions that were made over the Labor Day weekend, a matter of days from the time that Spiro communicated with Chantel Courtney, the fundraising person at U of T, to the decision made by the dean, communicated to Professor Macklin, was just over a few days. And his reasons that he offered Professor Macklin, if I recall correctly, had to do with cross-border hiring and the difficulty of hiring Azarova, who was in Germany at the time, and it was expected would be moving to Canada with her family. And it turns out that this was exactly what she wanted to do because her husband is Canadian, and she and her children and her spouse were all going to return to Toronto for at this opportunity. So the cross-border hiring was a problem. Iacobucci mentioned to Macklin that her scholarship was an issue, but wasn't decisive. He denied having said that to Macklin in his interview with Thomas Cromwell, which we'll come back to a bit later. And there were other reasons that then showed up, and one of them had to do with timing, and that is that the position had to be filled before September 30th. Negotiations with Azarova began the second week in August. There was no communication to the IHRP committee that was making a decision about appointment that September 30th was a deadline. So this was a closely held deadline that only the assistant dean Archbold and Iacobucci knew about. And then subsequently, there's yet another reason associated with cross-border hiring, and that is it would have been illegal to hire Azarova as an independent contractor as a stopgap measure while she was in Germany and before she came to Canada. And I'm happy to I'll fill out and respond to some of these excuses a little further along.
All right, well, thank you.
Yeah, you're welcome. So let me then pose a few questions to you. And that is, we know that over the Labor Day weekend, the dean decided to scuttle the appointment of Valentina Azarova on a number of what we, our group, described as pretextual, that is, excuses made after the fact, denying that Judge Spiro's complaint and implied threat about the Jewish community being upset about the hiring of Azarova. We know that this happened over Labor Day weekend. So what helps to explain opposition? Indeed, I think precedent would suggest that there would be no opposition. In regard to other violations of academic freedom at the University of Toronto, it's hard to find groups coming together, small or large, to oppose those violations. So what happened here? What explains how this group, of which you and I were members, came together?
Yeah, no, that's a great question. I mean, in many ways, it came in the context of this hiring scandal. I think for some there had been a long-standing buildup of frustration around lack of accountability from the dean's office. I think in some cases it was about the desire to be as proactive about the IHRP program, a program that had already suffered financial setbacks as the dean was cutting its budget from the year prior, where leadership had been stifled because the leadership had been waxing and waning as directors came and went in the context of a program that seemed under-supported and underfunded in the law school context. And I don't want to underestimate the significance of our colleague Audrey Macklin, who on the committee has always been, for many of us, sort of a stalwart, a figure who of a lot of respect. And I think we all sort of knew that Audrey was not the kind of person that would speak up about something unless it really mattered, unless it really was significant. And those of us who know her and respect her know her to be of that nature. But I also think for a number of us, it was about how do we work together to think this through. I'm mindful that our colleague Ariel Katz is on this right now. Ariel was part of this group. Kent Roach, Anna Sue, Trudeau Lemon, so many others were part of this. And I do believe that there's a vocal cohort of which we formed about 7 to 10 that was committed to a robust academic freedom principle, recognized that it was under threat in this context, and also in the context of a limited collegially governed, of an uncollegially governed law school. So, we did come together in that way as a group. But I would like to talk about the group because I would have to say, for me, that I've been at the Faculty of Law since 2005, and those of us in this group of dissenters, we were called a small group of vocal dissenters, almost sort of pejoratively, as if we weren't really that significant. But we had all known each other, but I don't think that we had all become, we were close, we were colleagues, but there was something about this controversy that also brought us together in a really meaningful way. We became closer. We became more than just colleagues. We became allies. We became friends. And in your and my case, we became collaborators on an article. There was something about the group as it came together that began to show this looks like what collegiality at its finest can do. As a group of 7 to 10, we worked together on crafting public letters. Those letters would, one person would have the pen and everyone would support that person. The pen would shift from person to person. So no single person had that responsibility. Working with Denise Rayom on crafting these letters was always a pleasure. Using technology, even as we're all virtually located in different parts of the world sometimes, we nonetheless coordinated in real time. And there was, it was almost like being part of a research collective committed to best practices in governance at a Faculty of Law, leveraging what we thought good legal education should do. And I think it was also that was a key element, is that this was a governance issue at a law school in which all of us were teaching about governance. And so we brought all of that to bear as a small group of individuals who were committed to those core principles.
So that sounds like a great experience. I'm of course glad to have been a part of it, but why didn't that generate more support or even expressions of interest in joining up with this group? What explains then the other 40 plus whom you never heard from?
So I can't speak on their behalf. I don't honestly know. But I do think there was a lot of anxiety. So, obviously on the one hand, in the absence of effective communication mechanisms internally by the dean's office, Ariel, who's actually on this call, created a listserv for faculty to join in and have this conversation. What was striking was how many chose to remove themselves from the listserv, who chose not to be part of the conversation and wanted to exit. So it was almost as if the culture around governance had become a personal ethic. There almost a self-disciplining into silence that had arisen because, of course, the understanding at the law school has been if you dissent, you're a troublemaker. And so there's that. We've theorized that it's also possible that the Palestine exception itself is a problem. It quiets a conversation. It is a hard conversation to have. It's a difficult one, and in a highly polarized context, there may very well have been anxiety that to interrogate the collegially ungoverned manner in which this was handled would welcome accusations of anti-Semitism, support for critique of Israel, and in a context where the IRA definition was gaining ground and traction. Those are some of the thoughts that I had. The last, of course, is the fact that we ended up having to take this, some of us, myself included, went into social media. And that was seen as a violation of like one of our colleagues, Brian Langell, writes how it was problematic for him that this became part of the larger social media landscape, that the newspapers were covering this issue. It became embarrassing to the institution and therefore to those who inhabit it. But in the absence of effective communication vehicles within the law school, these were all that was left. And so I think it was a combination of reasons, none of which we necessarily know for sure is why people were silent, but all of which I suspect were in the air.
Yeah. And it's important to note as well that the job for which Azarova would have been appointed to was not about Israel-Palestine, but rather was running a very, aside from defunding, rather successful and very popular among students international human rights program. So her job, in fact, was far removed from her scholarship. It might have been the case that it would have the work of the IHRP would touch on those matters, but there was not a lot of. It wasn't necessarily the case that the Palestine exception and Israel-Palestine would be central to our conversations as a faculty. Instead, I think the strategy that you employed was to invite others to participate in discussions about academic freedom and collegial governance. So just one last question here on this part. What kind of things were you hearing in conversation with faculty colleagues, to the extent that you had those kinds of conversations?
No, that's really helpful. That's a good question. I mean, we heard a number of, there was silence for one. There was expressed concern that the tenor and tone of the conversation was too strident. So there was one sort of almost a kind of tone policing of the conversation, which was odd. But in terms of, those supporting the dean, there was a lot of concerns around, and this was a dominant theme that we had to address as well. The director of the IHRP is not a faculty position. It's a professional manager, and professional managers don't enjoy academic freedom. So there is no academic freedom here issue at all. Alternatively, well, actually all appointments at the law school are at the pleasure of the dean. And while we have committees that operate in these selection committees that work to identify and focus on, top candidates, all appointments are at the discretion of the dean. So a lot of discretionary authority, which of course goes back to our argument that the culture of governance doesn't really enable these committees to do the work in a collegial manner without a sufficient deference to the dean. So those are I hope that answers your question.
Yeah, it does. Thank you.
So what I'd like to do is, one of the figures in this scandal that looms large is former Supreme Court Justice Thomas Cromwell. And he issued a report at the behest of the university to do an investigation or an inquiry, or he called it a review of what happened and how things could be improved at the university for purposes of academic freedom. And so one is, I was wondering if you could talk to us a little bit about the appointment of Thomas Cromwell and his role, how it came about, but also some of what his appointment meant to you and to those you were in conversation with, about his appointment also raised some concerns.
Yeah. So let me begin by saying the appointment of former Supreme Court of Canada Justice Thomas Cromwell came as a bit of a relief at the time. In October, we were asking for a review of the dean's behavior. We were stymied, told it was unnecessary. Pressure continued to build. The president of the University of Toronto appointed Bonnie Patterson to conduct a review of events at the law school, and her appointment was problematic given her own violations of academic freedom and her professional association with university administrations. So after banging the drum on that appointment, Gertler then reversed and then hired Thomas Cromwell, who is in private practice with a large Canadian law firm after his retirement at the Supreme Court of Canada. And it seems that these kinds of reviews are now the kind of work that retired Supreme Court of Canada justices are being asked to undertake. So Cromwell just did a review, I think, for Hockey Canada. And this was yet another opportunity for a retired Supreme Court of Canada justice to conduct, obtain a brief. It's important to understand that Cromwell was being retained by the University of Toronto. The University of Toronto and the president were his clients. Gertler outlined a mandate for him that looked reasonably objective. So it's a fact-finding inquiry about what happened. Were there any violations of university policy? And so we were eager actually to find out what Cromwell could learn, because in fact, much of what had happened was not being disclosed to us. We could only surmise what was going on. And we had some confidence that Cromwell potentially would find events here at the law school really objectionable. Cromwell himself was a law professor at Dalhousie for quite a long time. He had served as labor arbitrator when he was an academic, so he knew how to conduct a hearing. He knew something about receiving and weighing evidence. And then, of course, as a Supreme Court of Canada justice, sitting at the apex of Canada's administration of justice, here's a man who would have a great deal of experience about weighing contending accounts of what's going on and trying to get underneath events here at the law school. So we were optimistic but cautious, right? Knowing that the dean was the son of a former Supreme Court of Canada justice, also former Dean Frank Iacobucci. Cromwell and Frank Iacobucci didn't share time on the court. Cromwell came right after, but nevertheless, we were a bit worried about the proximity, right, of these Supreme Court of Canada families. And we came to be aware of the fact that really, practically speaking, we were taking on the Canadian legal establishment. And so we expected, many alumni and, of course, faculty here at the law school to stand either silent or by the dean. So we were looking forward to the report, which appeared in April of 2021. The report was held by the president for 2 weeks, inexplicably, really, on the eve of a censure vote by the Canadian Association of University Teachers annual general meeting. So that's that was a lead up to the report. And I'm happy to talk more about some of the details.
Yeah, well, actually, I wanted to ask about that. It's not an easy report, right? I mean, it's a long report. It's got a lot of narrative facts, and it goes into not only what happened, but his own assessments, and then, of course, what university might want to undertake thereafter. I'm wondering, for the benefit of the audience, if you could tell us a little bit about some of the concerns that you had in reading the report, analyzing the report, and the way Cromwell himself addressed conflicting factual accounts.
Sure. I mean, the principal problem with the Cromwell report is that in part 2, when he evaluates the facts that he's gathered, which he reports in part 1, in part 2, he accepts everything said as true, which seems impossible to do when you've got conflicting accounts. For instance, simply consider the telephone conversation between Macklin and Iacobucci that Sunday over Labor Day weekend, in which we have a disagreement over what was said. So if that's the method that Cromwell employed, and that is to accept everything that is said to him as true, then everything that Dean Edward Iacobucci said to him is accepted as true. In which case, everything that Iacobucci claimed, that he wasn't influenced by a donor, that he was certain that it was illegal to hire Azarova in Germany as a stopgap measure, that September 30th was a hard stop for the appointment process. Cromwell accepted every one of these things as true, which meant that Iacobucci was absolved. Cromwell concluded the report by saying, "I will not draw an inference that Iacobucci acted pretextually, that he made up these excuses after the fact." But by looking at part 1 of his report, which is the fact-finding part of his report, we learn many things we didn't know before. And by interrogating and reading that report with a critical eye, it becomes obvious that many of the excuses that Iacobucci offered, that we claimed were pretextual, were highly problematic. And so it seemed to us that Cromwell didn't really take seriously the facts that he'd gathered in part 1 in his attempt at absolving the dean of any responsibility in part 2.
Thank you very much.
There's a couple of things, though, that I should mention, although we're quickly running out of time, and that is Cromwell accepted that hiring Azarova overseas would be illegal. And Cromwell accepts this really without question at all. And we learn in part 1 of the report, in the fact-finding part of that report, that the term illegal is used by German employment lawyers who were consulted about hiring Azarova as an independent contractor, were used by them to describe what would happen if the German authorities decided that she was an employee and not an independent contractor. If she were an employee, it would be illegal if the university did not pay her Social Security benefits, analogous to employment insurance benefits here, right? So in other words, because the university refused, I gather, to pay those Social Security benefits, it would have been illegal. So rather than paying fairly into that Social Security fund, Iacobucci preferred to simply adopt the claim that this was illegal to hire her. And so there were easy solutions to these claims about illegality, among them paying Social Security benefits or simply just waiting until she got appropriate documentation to enter into Canada and begin her employment here.
there's another issue in the report that I was hoping you can address, is the timing issue, because Cromwell had to decide whether or not Azarova, being unable to start her position in Canada by September 30th,
Yeah.
was in fact a material considered decision. And yet it's not clear that anyone actually knew about this September 30th deadline. And so I was wondering if you could just address that, about the report, both how Cromwell deals with that, but also some of your thoughts on how we should understand that curious issue.
Yeah. So I'll talk about this very briefly. Negotiations with Azarova began, I think the first reaching out is August 17th. It's entirely unrealistic to have expected that the negotiations over terms and Azarova's arrival in Canada as a non-Canadian citizen beginning work here would have been completed by September 30th. Nobody would have believed that that would have been a possible date to meet. Yet negotiations were ongoing until the dean scuttled the appointment process. The September 30th date was known, according to the Cromwell report, only to Assistant Dean Archbold, who was on the IHRP Appointments Committee, and the dean. It was never communicated to the other two members of the IHRP Appointments Committee. So this is a hard stop date that wasn't communicated to anybody else, but was closely held within the dean's office. So it's simply not credible, just by virtue of the timing of negotiations with Azarova, the failure to communicate, and Archibald, in her evidence to Cromwell, so he reports, says, I can't say for certain that we ever told anyone else about this date. I think buttresses the suspicion, right, that this wasn't real, that this was a hope, this was a wished for date, but not anything that realistically could occur, particularly if Azarova's appointment would be scuttled. The dean was beginning to reach out to other Canadian citizenship candidates. All of that would not have, nobody would have been in place by the end of September. And moreover, the September 30th date had no real relationship to the IHRP program. And that is that Azarova herself could have been working on this, as I say, as an independent contractor or employee from Germany. And there's a course that's offered. It begins in January, and we're all working remotely. So it just simply seemed unrealistic to rely on that hard date.
Thank you very much, David.
All right. So let's move to what happens after the Cromwell report, Anver. And we're moving towards a censure vote by the Canadian Association of University Teachers. And our account is going to end at that moment. That's a story that needs to be told for sure. And it's not one that we're going to talk about here. But what happened after the Cromwell report is released and in the lead up to the CAUT vote of censure?
No, I'm happy to talk about it, although I say it with some mixed feelings. I'm also mindful of time, so I'm going to speed through some of the issues here. So what the record revealed to us as we looked at the CAUT collection, CAUT had collected a number of materials, including letters from colleagues of ours at the Faculty of Law, and some of the materials were internally created to address the Cromwell report. They had their own assessment of the report and the state of affairs that would happen at the law school. They had a number of different letters back and forth, but there were 3 letters that they got from colleagues of ours, which were fascinating to read because effectively this was one of the first times we have publicly available documentation of what our colleagues were thinking and how they supported the dean, how they understood what the dean was saying. And so what was impressive to us was how silent they had all been, in contrast to the fact that we had a bit of a research team that was writing and making all of our arguments open and transparent. In fact, every letter we did was publicly posted on the Ultra Vires newspaper, a law school-based student-run newspaper, which created its own archive of all of the reporting on the controversy. But we have a couple letters that we address. One is from David Deisenhouse, whose letter basically suggests that, number one, we have these uninformed colleagues who've been quite vocal on these matters, but imposing censure would not do anyone any justice. It runs contrary to the findings of Cromwell. And moreover, it made the argument, or Deisenhouse made the argument, that we have a brand new dean because Iacobucci's term had ended in the December of 2020. So now we're in 2021 and we have a brand new dean. If you impose censure on her, on the university, then there'll be no way for her to work on reconciliation within the faculty. This was the language used in the Cromwell report, to reconcile the faculty to one another when censure would effectively embolden those who have dissented this entire time. Larissa Katz said effectively the same sort of emotional argument, though her position was that that those of us who dissented did so without knowing the state of the facts. And she seemed to intimate that, again, the leak about Azarova's hire may very well have been Azarova herself or Audrey Macklin herself, though we find that incredulous as to how or why they would leak this appointment process to Gerald Steinberg of NGO Monitor. Brian Langel's letter was interesting to us. It made the initial claim that the Cromwell report met any legal standard one could think of, even though Cromwell himself writes in the report that because there are no sufficient judicial safeguards to his liking, he's not going to use legally available methods for assessing credibility at all. So it was almost as if they hadn't read the Cromwell report. But all three of them were convinced that to impose censure on the U of T would undermine the new dean's ability to bring the faculty together. And I want to pause on that because it's a fascinating argument. What would preclude the faculty from coming together and talking? And what we realized is that it was necessary. The reconciliation, according to these letters, was only possible if the small group of dissenters who had clamored for greater collegial governance were shown to be wrong, were shown to have been wrong all along. Well, our position is simply one of saying we can still have a conversation around collegiality, but we have to maybe think about how we read the Cromwell report. We have to reconsider what a legal standard is. We have to rethink our assessment of the evidence. And if you're not willing to do that, as these three were clearly not willing to do, then yes, we don't have the ability to have a collegially engaged environment. And so, for us, writing about these letters was hard because, again, these are our colleagues, but they are indicative of a larger conversation that we need to have around what does it mean to collegially govern? What is the place of dissent? How do you engage dissent, and how do you integrate it in a collegially governed model of a law school in support of academic freedom? And these are conversations that we haven't and most likely will not have at the Faculty of Law.
That was excellent. And I think it's a good moment at which to turn to questions.
Yeah. So Ange, we're going to ask you to help us take the first question.
Hi, yeah. The first question is from Garfield Emerson. And it's a quick one. Where's your article published?
Oh, well, it's currently on SSRN, the Social Science Research Network, but it is currently in process and under review with editors at, I believe it's the Canadian Journal of Labor and Employment. So we're hoping for a 2023 publication.
And I do believe we'll be posting a link to that paper
Yes.
along with the video of this session.
Okay, next question. Yes, and we will be posting it tomorrow, a link and with the video. The next question is another one from Garfield Emerson. Did either of you speak or communicate directly with Dr. Valentina Azarova? Did they, and asked if you got any documents or evidence from her regarding her discussions with officials at the Faculty of Law during her recruitment process before it was terminated by Yakabuchi?
No, and in fact, we never spoke to her. And I think in many ways, well, I didn't speak to her. And in many ways, it was important for us because we knew that the backdrop to this situation was, of course, the Palestine exception. But our approach had always been one of governance, one of collegial governance in support of academic freedom. And so for us, trying to understand her research, her academic record, the validity of what she had been doing in the research area wasn't the approach that we took to thinking about how do we preserve academic freedom, even over controversial topics, regardless of what they would be. But I'll leave it to David to follow up.
Yeah, so I made it a point of not contacting Valentina Azarova, but I did have a brief email conversation with her as she sought disclosure of internal U of T communications regarding her appointment. So I tried to put her onto a lawyer who could give her some advice about the Privacy Act in Ontario, because the University of Toronto was refusing to disclose communications regarding her appointment. And that was the only communication I had with her.
Ange, can we have the next question?
Yes, the next question is from Bill Bruno. Why did the dean think he could get away with non-appointment of Professor Azarova? You say that communication among the faculty members is difficult, but maybe the dean is similarly unable or unwilling to communicate with his own faculty. If he could get away with this authoritarian gesture, what would be next? Was this merely the thin edge of a big wedge?
Shall I weigh in first?
Yeah, please do.
The dean thought he could get away with it because the dean gets away with most everything. And to describe the dean's behavior as authoritarian is, stretching the analogy, but it's not far off, in the sense that the way in which the institution, this unit, is run is very top down. We are told what's happening, what to do. We are expected to yield. We're expected to follow. It's a culture of complacency, it seems, that fuels that kind of leadership hubris, that the dean can do anything. I'm relatively confident that the dean thought that he could do what he did over that Labor Day weekend because no one would call him out. That's the culture at this institution. But I think, to his regret, he got called out, and we, our so-called small group, repeatedly questioned his behavior, and for that reason, we were characterized as disloyal, are being shunned in some quarters, and that's that. So the culture of the institution, it seems to me, encourages this kind of behavior by the dean.
Actually, can I also add to that is that, it's not even just at the decanal level within the law school. I mean, if you look at the way, one of the things that we began in this process was also thinking about how is it that we appoint deans at the university? And there's a larger conversation that hasn't been had on the decanal appointment process itself, one that's done virtually in secret. We almost always know who the main applicants are. But whereas other law schools will have conversations with candidates who want to be dean, we're not even allowed to talk about it with the candidates. The candidates aren't allowed to talk about it with the faculty. And so the level of secrecy that goes in the selection process of the dean also creates the condition for the exclusive nature of that position.
Yeah, yeah. And we haven't touched upon the president and his cohort at the center of the university. And for the most part, and we were writing to them repeatedly throughout the episodes we're describing, and we got pretty brief replies, basically the back of the hand. And it was only actually by public exposure, newspaper accounts, et cetera, that we got the president, for instance, to move in the appointment of someone to investigate these matters. So it was shaming, really. It was public shaming was the only way that we could get some action at the center of the university.
And next question, please.
Yeah, the next question is from Maya. And Maya says, I have a question for David. You asked Anver why so many faculty were silent, avoided involvement in one of the most significant governance controversies in the law school's history. Why do you think most of your colleagues, especially those with tenure, ducked for cover instead of getting engaged as members of the Collegium within the law school in this flagrant violation of academic freedom?
So, Anver, I think I asked you that question.
Yeah, no, they're specifically asking you because I already gave my answer.
Oh, okay. Okay, I get it. Well, I've described the culture of complacency and silencing at the law school. We're all expected to keep our head down. We're not expected to intervene in internal governance at the law school. And if we do so, we're labeled as troublemakers, disloyal, and other things. So that's the context in which all of this operates. And so colleagues then were behaving consistent, right, with what they've been taught and what they've learned over time here at this institution. But I don't think that it's peculiar to this place. I think many places at the University of Toronto and other universities, faculty rarely speak out, and that those who ring the alarm bells around academic freedom are often left alone. And in our case, it's important, as I think the questioner indicates, that everyone here is tenured. There weren't just some tenured colleagues, everyone had tenure. And yet they didn't feel they had either the authority or bravery or knowledge. I'm relatively confident that some colleagues didn't intervene because they didn't really know what was going on. Well, neither did, I mean, we knew only what was on the record. We knew only what had been released by virtue of a timeline that Professor Macklin had drafted up, and only what the dean had said. We were asking for an investigation to learn, in fact, what had been going on. And it seems to me even that simple inquiry didn't require a lot of bravery. Rather, it should have been insisted upon, but remarkably, in a law school that is preoccupied with things like the rule of law, governance, checking authority, that these kinds of concerns didn't warrant intervention by all of the faculty.
And next question, please.
Yeah, the next question is from Carolyn Sale. Carolyn says, it is cheering to hear about what several of you at the Faculty of Law were able to accomplish by banding together. You were able to do your work as part of a research collective, as Anver has noted, from your respective expertise in governance. The situation is so much harder for faculty who do not have this kind of expertise. Help. What advice do you have for such faculty?
Well, I mean, if I could begin, I actually think early on, talking to UTFA was actually quite helpful. UTFA has some great lawyers, and but they also I was really impressed with their capacity to get involved. So that was number one. But number two was we were really fortunate, especially once censure occurred. Like, again, our paper stops at censure. But once censure happened, then Censure U Toronto took off. That's a whole other movement that we don't write about, but it deserves a paper of its own, because it wasn't just, because by the time we had gotten to the point of censure at the law school, we were ready to, we were tired. There was a certain level of fatigue. And then all of a sudden, this group of faculty from across the campuses, all 3 campuses, got together, organized really intensively, and were incredibly creative and proactive and probing and provocative. I actually have to acknowledge that it was Censure U Toronto, which was impressive. And they were not necessarily lawyers or legally trained. They were, but they were very strategic in the way they thought about how to be publicly engaged, how to showcase their critique. And so I don't think that you need the kind of legal training that the dissenters had at the law school. But I do think that bringing people in who can be allies from outside, who have that capacity and the interest and the ability to take an issue like this and facilitate broader awareness was incredibly important. And of course, for us, it was also creating a public record. Our team of dissenters, we would write together, but we also knew that simply emailing and keeping it quiet wasn't going to work. That's why the Ultra Vires archive became really important. And I did forget to mention that archive and the Censure U Toronto archive were important sources for us in writing the paper. So really working with the existing institutions that allow for public engagement, but in a meaningful way. I don't know, David, do you have any other thoughts on that besides?
No, I think that's right. OTFA is the faculty association, and so faculty associations and unions, whoever represents the collective bargaining unit, will typically have some lawyers on retainer who can provide some advice. And it's true that once the matter reached beyond the confines of the law school, we had some wonderful allies who were clever, strategic, and really knew how to mobilize academic and public opinion. And that really was helpful and critical, really, to success. The University of Toronto offered Azarova the position. She declined. But the university reversed itself. It was an extraordinary victory and secured really with the Censure U Toronto movement.
And the next question.
Yeah, the next question is from Chris. Chris says, you've told us about what happened within the law school. Are there lessons from this case about what faculty and other universities can do to make collegial governance and academic freedom a reality?
Well, we end with some of those reflections in the paper, and we were running a little long on time, so we didn't get to that part. But I would say one of the things that struck me and has struck in the process of thinking about this issue, thinking about the law school environment that we're in, is there's very little that actually documents and structures how the law school is to be governed. So the only thing that exists by way of faculty governance documents is behind a password protected portal on the website of the law school. And when you scroll underneath that, there's a link to what are called faculty governing documents. And when you look at those faculty governing documents, most of them, I would say almost all, but maybe with the exception of 1 or 2, are really about who sits on faculty council. More specifically, what student number composition, like what's the composition of student membership in faculty council. And so faculty council's membership becomes the issue. And there was a back and forth conversation around how many relative to how many faculty and so on and so forth. There was never a doubt that the faculty were on faculty council, but it was always about student engagement in that process and accountability to the students. And what we didn't find was a bylaw of how do we run the faculty? What is the authority of the committees? To whom does the dean answer? Even something as simple as faculty council, the dean both chairs the meeting and sets the agenda, as opposed to other contexts where a presiding body or a presiding individual would chair faculty council to which the dean and the dean's office are beholden to respond. And so these are just some basic sort of governance 101 elements that seem to be missing in the public record. And so my suggestion, of course, is to create a record of how it is we govern without assuming that we'll always achieve collegial governance and academic freedom, like some saccharine idea. If we want to actually care about these things, if they matter to us, we might actually have to write them down in a way that we didn't think we had to.
Yeah. Any good lawyer will tell you, you need to document things. You need to prepare for contingencies you don't want to occur, but might occur. A breakdown of collegial governance, for instance. That would be good legal advice. It seems that we don't take that advice here. We've refused for the longest time to document how faculty council governs. We're now actually, after this affair, on the road to trying to draft a constitution for faculty council really late in the day. So writing things down is my advice. And there are templates available on the CAUT website, but the kind of language that might be included in governance documents to declare a commitment, right, to collegial governance, to consultation, to co-decision making rather than top-down decision making. So I think that's the path forward, is to document things.
Ange, next question, please.
Yeah, the next question is for Mariana. And Mariana says, has the change in dean made any difference to the lack of collegiality at the law school?
It's a great question. I mean, I think that the dean was saddled with a scandal not of her own making. And so I am sympathetic to her plight. And what was important when she first took on the role was that she did have a listening tour where she listened to everyone, and a number of us attended one of those sessions with her. But for me, one of the concerns that I have is, and she allowed us as authors to quote and cite her memo to the faculty, but she wrote a memo to all of us talking about what she found in the process of that listening tour as a return to collegiality is what everybody wanted. But my concern has been and remains is like, well, we don't know what collegiality actually means. And socio-legal studies and sociological studies suggest that terms like professionalism, civility, collegiality, these are disciplinary terms that oftentimes can, where they're silent, maintain the status quo. So when it comes at least to the crisis, we've had silence and only silence on all the matters that we've raised today. David, did you want to add anything?
Not really, just that there's been the listening tour that the dean went on prompted her to conclude that there would be no discussion amongst faculty. We've never had a faculty-wide discussion about the Cromwell report, which is why the letters that Anver referenced were supremely interesting to us, because we've not heard anything from our colleagues about the Cromwell report. And what we learned is that they didn't really read it very carefully, if at all. And we will never have that conversation, it seems, which prompts some people, some colleagues in the hallways of this building to refuse to even politely acknowledge my presence because they think they're right. So they've never been challenged about their assumptions about these events, and we're wrong. But we'll never be able to plead our case, though, again, everything that we did was made public. We made sure that every piece of writing that we submitted, even the Cromwell submission, we posted after the Cromwell report was released. So everything is publicly available, and we were inviting our colleagues to engage with us about the very facts that we were trying to interpret and discern. But we've been met with either dismissal, as in these letters, or utter silence, and that this will never be a subject of faculty-wide discussion, it seems to me.
Ange, do we have time for another question or two?
Yeah, I think for at least a couple. The next question is from Isaac, and Isaac asks, what role has the anti-Zionist sentiment prevailing among many North American scholars in the public discussion of this case played?
I mean, for us, I would say that it was largely, and as we write in the paper itself is not about Israel or Palestine, and it's not about even the Palestine exception. We acknowledge it as existing in the background, but I do think that for us, the focus has been and continues to be collegial governance and academic freedom as a nexus item. One is a sine qua non of the other. It could be any situation: India and Kashmir. It could be China and the Uyghurs. It could be Burma and the Rohingya. Any of these sort of situations would create potential possibilities depending upon donor interests. So, David, do you have any thoughts on that, or?
Not really. I think that's right. We were trying to reach out to our colleagues and to the larger university community in our critique of the dean's behavior, and not trying to focus on Israel-Palestine, though we will know that it was at bottom what was precipitating the donor interference and the dean's decision. There's much to be said about this subject, in particular interventions by B'nai B'rith and others, but I prefer not to give those kinds of interventions any more oxygen than they've already had.
Ange, back to you.
The next question from Manzar. What are the larger societal implications of a major faculty of law operating under a governance model that is not collegial and has wide discretionary powers for one person to shape the faculty? And what kind of a system of checks and balances could be put in place to make such an important institution in our society more transparent and accountable?
Well, I mean, I think, we tried to address some of those in terms of, implications around putting things in writing. I would simply want to add one item, is that we know in our current environment that universities look to private donors now. That's just a reality. As provinces begin to reduce their funding of higher education, as higher education itself and advanced research and innovation becomes more costly, private philanthropy is one vehicle to support innovation. And that puts deans and other leaders in a potential conflict of interest within their own office. On the one hand, part of their office is about collecting and supporting, getting philanthropic support. The other part of their office is supporting a curriculum, enhancing the academic rigor of their program, and advocating for their faculty. We don't deny that a dean in that position is caught in between these two conflicting purposes. We simply believe, I simply believe, that what you need to do is create more conflicts of interest mechanisms of reporting so that they're part of the governance process. They're part of a transparency and accountability mechanism to ensure collegial governance. And that was what struck me as odd in this particular conversation, was the absence of a conversation among colleagues around how do we manage conflicts of interests when deans in the normal course of business are, of course, they're going to come across these sorts of conflicts. It's the nature of their job. No one denies that the dean is to talk to donors and the dean is to make hiring decisions. No one's going to deny that. But how do you regulate that process, that multifunctional role in a conflict of interest situation? And we just need more clarity and transparency.
Yeah. So we have time for one more, don't we?
I think that's it, actually. That's
Okay.
all of the time that we have left. I'm sorry that we didn't get to everybody's questions, but thank you all for putting them in.
Well, I'll turn it back over to Jim then.
Well, I'd just like to thank the two of you. I found this a fascinating, engaging discussion, and a discussion about an issue that's so important for every university across the country. And the issue, as you very cogently put it, universities really are based on these twin principles of collegial governance and academic freedom. And whether they're acted upon or not makes a huge difference. In many cases, they're not being acted upon. So your case study, I think, is very useful. And I would say to everyone who's in the audience, tomorrow the Center for Free Expression is going to be posting a video of this conversation. So if you have colleagues who you would like to have listen to it, please direct them to it. Our center's website is cfe.torontomu.ca. And you can just click on events and it will have a video. And as was mentioned, we will also post along with the video resources that were referred to here that you might want to look at. The Cromwell report, we'll put up a link to Anver and David's paper and other related materials so that you can look into this case study more if you'd like to do that. Our next event is going to be a week from today, November 16th at 2 p.m. Eastern Standard Time. And it's going to be the first of this series that we're doing, looking at how ethnic religious nationalism impacts with academic freedom, how scholars of a certain country or can be attacked, threatened, their work interfered with because of opposition by governments or political or ethno-nationalist religious groups. This first one is going to look at Israel and Palestine. The next one is going to look at India. The one after that is going to look at China. In all cases, really interesting work where we're going to have leading scholars talking about the challenges they face just in doing their work, because it raises questions that governments or various civil society groups in that country don't like. So that's going to be next Wednesday, November 16th at 2 p.m. All the details are on the CFE website, cfe.torontomu.ca. So I want to thank Anver and David again for what I thought was a wonderful conversation. And I want to thank all of you in the audience for coming with us today. Bye-bye.
Thanks, Jim.